You chose not to, whatever reason, you didn't want to face a trust vote.
I face that squarely. Allow me, Malus, I'll change my sequence and come to this first right now. May I, Malus? Because straight away your lordship's conscience should be satisfied. This is a red herring. It should not deter, will not deter in law, your lordships. If your lordships comes to the conclusion of the other one. What happens in my first point of affirmative and negative? If your lordships were to accept their interpretation, that's a good way of answering my Malus proposition. Namely, your lordship will have nothing left in the 10th schedule. How does the lordship operate? Both the 4-step or the 3-step becomes the norm and will be followed in every case to defeat the 10th schedule. That's my first point. Second point on resignation. The most important thing is it's a prior challenge. The illegal act of the governor is a prior pending sub judice challenge before the trust vote.
So you are really saying that Mr. Uddhav Thackerey resigned only because he was called upon by the governor to face a trust vote?
I'm grateful. After I had filed a petition, after I had made it sub judice, and after I had said this is completely unknown to law, don't allow it to go on.
And you are frankly accepting the fact that, well, you resigned because the trust vote was going to go against.
When you do an illegal act, the consequence of that is known to me. The CM's participation or absence of participation would not dilute that fundamental illegality. If it's illegal, it's illegal. How does my non-participation validate the act of the governor? Is the core question. That's the correct legal answer. Today, the illegal government is running. There is no elections. Then, and the person who otherwise, suppose the lordship holds the governor to be bad, then a person not entitled to be holding the post of chief minister. How can, of all courts, the Supreme Court accept such illegality? If your lordship's powers are unique in this country, in that even your lordship's can go beyond the law. Not contrary to law, beyond the law. Then what's the point if the governor's actions are held to be illegal? Actually, your lordship would be giving a Pyrrhic declaration and accepting that the illegality has borne the fruits of its illegality and people have enjoyed it.
What is the point, Dr. Singhvi?
Yes. Now, a very strange argument was raised, de facto doctrine, regularization and validation by 189. Mr. Salve argued at length. Mr. Mehta also argued.
Page 189, I'm sorry to interrupt. What is 189?
No, page 1.
Page 1 of my note. That is the de facto doctrine that actions validated by the actual act which is challenged is illegal. I want to show how wrong this can be and how dangerous it is. The first important thing is, there are two kinds of challenges. One is a challenge to the very validity of the act. So I challenge a validity of an act. Let us say the Governor's Act. Let me say competence of a legislation. Let me say fundamental rights versus the eligibility of certain people to act under the act, to sit there and act. Your lordship under 189 protects the second, not the first. If the governor's action is bad, will 189 ever protect it, Mr. Malal friends, two of them argued at great length on 189. Did they answer the question? Ultimately, the core question, my lord, is just formulated either way, this way or that way. Is the governor valid or not valid? If your lordship holds him to be invalid, 189 comes only after your lordship holds something to be invalid. Otherwise, it doesn't come into play.
It can be said in the context of the vote in the House.
So,
with respect to
exactly. So, therefore, 189, your lordships can and may, and in this case, perhaps should, in the intervening period of 7-8 months, the decisions taken by an otherwise illegally constituted government may be valid under 189. That's the real commonsensical way of implementing it, I am not suggesting that somebody's appointment is quashed, somebody's transfer is gone, somebody's policy decision.
So what Maharashtra government has made a liquor policy, therefore that is gone. What saying is that Article 189 recognizes a de facto doctrine.
De facto doctrine.
What the de facto doctrine does is to legitimize the acts of an authority whose original appointment is found to be invalid.
Subsequently found to be
invalid. Correct. But that does not validate the original appointment.
That's the one sentence pithy summary. Or calling for, that goes back to the same thing. First act was what? The governor being approached, governor calling. The two others are consequences. Voting is a consequence of the governor's illegal act. So is the oath taking. If the original act is bad and your lordships can't validate it, then this will not validate the vote. The consequence is bad. The consequence of an illegal origin cannot validate the illegal origin. And similarly, 189 cannot...
What you're saying is that if the calling of the voting in the House itself is subject
to... Just how my lord's formulation was, right or wrong, governor's action, A, no basis, and B, if basis, it is wrongly applied, etc.
But that's affirmation of the House, right? Then what? I still have...
Affirmation is coming. That's this section. Bomai dealt with the affirmation.
All right.
Bomai said, we hold something to be illegal. Let's kindly give a minute, this is very interesting. But thereafter Parliament has approved it. Exactly the same thing. How can we quash it? Said, no, sorry, it will be quashed. Much worse, fellas. Here there was nothing, in our case there was nothing. There was a presidential proclamation affirmed by Parliament in Bombay. Now, fellas, the fourth point is this, fellas, prospective and retrospective of the EC. Look at the consequences of holding otherwise. There will be, fellas, very, very strange consequences. Two things, fellas. If your lordship were to hold the 19th July, that's the date, order of the EC, sorry, 17th February 2023, I'm sorry, 17th February. Petition is filed on 19th July. 17th February is the order. Now, well, the order to be retroactive, question number one, retroactive from when? There are three possibility retrospectivities. Look at the consequence, whether the lordship doesn't hold it to be without the consequence. Three. One is, it is retroactive from the date the Shiv Sena was recognized as a 29A political party. That was in 1990 or 92. I'm giving you three alternatives. I'm not... because today I am the Election Commission, I hold that this is the Shiv Sena. If it is retroactive, logically it should go to the date when 29A. But let's leave that. Second, it goes back to 21st June when this action started. And third, it goes to 19 July when the petition was filed. There are only three possibilities, Malas. In all of these, the consequences would be that, Malas, actually everything, I would be guilty, but I am actually, I mean people who have remained with Mr. Thackeray. I'm just using a phrase because there's no other phrase available. And people who have left. Now, the people who have followed the 10th schedule and remained with Mr. Thackeray would be actually liable for disqualification if your lordship relates back that. So your lordship would be giving a premium to those who follow the 10th schedule, and the people who have not followed the 10th schedule will protect their disqualification also and disqualify me also. Whereas your lordships will not avoid the inevitable consequence by, of course, your lordship's words can always, that's the logical consequence of retroactivity. They would make an arc of immunity for their own disqualification and actually be liable because the party from 19th July, any whip, any order, everything, I have violated because I'm not the party from 19th July. And therefore, Malas, I'm liable to something. Or from actually, logically speaking, from the origin. Therefore, Malas, this... And Malas, it would have the strange effect of an election of Mr. Uddhav Thackeray in 2018. Would also go without there being a fresh election unseating him. Everything will go, Malas. No adjudication. By the mere act of recognition relating back either to 1990s or to 19th of July or to 23, 21st of June. Well, there would be chaos. The consequences are, and apart from the fact that this is clearly textually not intended by the symbols order. The fourth and the last, under this head, I'm not on the next one, under this head, it would also destroy, not collateral damage, major direct damage. It would destroy the relating back which is held by a lordship with Rajendra Rana. Now, note this. Not a single judgment even of any High Court, leave aside Supreme Court, says that the Election Commission will relate back. A constitution bench has held the field for very long saying a disqualification 10th schedule order relates back. If your lordship were today to do this, your lordship would be giving primacy to an order under a symbols order with any judicial precedent not saying so versus a constitutional provision already held by a constitution bench to relate back. And your lordships cannot reconcile a relation back of disqualification with a relation back of the EC. It can't be reconciled. Today, Malas, suppose tomorrow the speaker disqualifies Mr. ABC. It is common ground by Rajendra Rana and many other cases. It relates back to June 22. But there cannot be disqualification because by then your lordship also would be applying a EC order retroactively. Therefore, Malas, your lordship already has jurisprudence and a precedent.
Prospective according to you.
Right. Then, Malas, the fifth aspect is this political party and legislative party. Now, Malas, F is a very important part. Actually, it goes to the root. This is the political party versus legislative party debate, but from an angle different than Mr. Sibal's. Actually, in practice, how we sit, where we sit, which rooms we are given, is all based on the collectivity of a party. Not an individual. Suppose a member is a leader of a party, he is very, very senior, but that party has only 3 seats. And another party with yesterday's first time member, but the party is a large number. Seats are allocated, rows are allocated, rooms are allocated only on the basis of party. That's the way it has to be. Now, prior to introduction, this is very, very important. Just kindly see this. This evolution has been forgotten in this argument of political party and legislative party. Prior to the 10th schedule, prior to 85, the constitution did not mention political party anywhere. Although in parliamentary democracy, the heart, as your lordship has in the English books, is political party. Westminster model is political party. It came in Malas for the first time with the 10th schedule, which is a constitutional recognition of political parties. And today your lordship has been asked to negate that recognition. Next paragraph. On the other hand, the concept of a legislature party has no legal or statutory basis. A legislature party by its very nature is not a permanent association of persons. Its life is coterminous with the term of the House. The very coming into existence of a legislature party is dependent on a contingency, the success of more than one candidate belonging to a political party. The 10th schedule defines a legislature party in terms of a political party. That is conclusive, I say. According to me, I may be wrong. It's conclusive. Legislature party is defined in terms of the political party. I've quoted the definition. And Malas, your lordship is concerned with a whip. Whip is peculiarly a political party activity. I'm 41. The purpose of defining the group of members of the House belonging to one political party as a legislature party can be gathered from the number of times when legislative party is used. First, in 2.1 it says, a member of a house belonging to any political party. What does it mean? Do you have an existence or identity other than the political party? After constitutional amendment and definition? Then, Malas, there is no mention of legislature party in para 2. In para 2, political party is mentioned. Thus, while referring to individual members, the 10th schedule refers to them as political party to which they belong and not in relation to legislative party. The only place in the 10th schedule where the term legislature party is used was either para 3, now gone, or para 4. In para 3, the term legislature party was used when the faction of 1/3 goes Malas. In para 4 too, it is for merger. Doesn't arise in this case. Doesn't arise in this case. Thus, wherever the 10th schedule provides protection to a group of legislators when acting as a group, it uses the term legislature party. Otherwise, it is described with reference to political party. Now, what is the consequence? This is a little important. The constitutional sequitur of this discussion is that a majority faction legislative party has no constitutional identity except for the purpose of setting up a defense under 4. This is important. Today, there is no status identity of a legislature party except for the defense of merger. That's all. And admittedly, that's not your case. Therefore, the group of legislators belonging to a political party can have no right of dissent or conscience. This dissent argument. Dissent has to be within the parameters of what 10th schedule allows you. Dissent cannot say and that's too broad a basis for your lordships to act or give any judgment on us. Dissent. I just say I'm dissenting and I leave the 10th schedule. Well, this dissent point which your lordship put to me just now also, let me end on that. Just see Justice Venkat in Kyoto. That para has been read one sentence, but read the whole of it. This is directly the point raised in Kyoto. Your lordship will not be referring to Nava Brave, your lordship will be reconsidering Kyoto also on this basis. Now, kindly see. This is a very important para. This para 49 at PDF page 109. Very telling para, directly the same sentiment. How do you harmonize the two and you cannot allow one to be reduced to vanishing point? Kindly see this. Indeed, in a sense, an anti-defection law is a statutory variant of its moral principle and justification underlying the power of recall. What might justify a provision for recall would justify a provision for disqualification for defection. Now, kindly see the exact sentiment which my lords expressed to me. Unprincipled defection is a political and social evil. It is perceived as such by the legislature. People apparently have grown distrustful by the emotive political exaltations that such floor crossings belong to the sacred area of freedom of conscience or of the right to dissent or of intellectual freedom. Can't be put better ones. The anti-defection law seeks to recognize the practical need to place the proprieties of political and personal conduct, whose awkward erosion and grotesque manifestation, it's grotesque in 92, I don't know how much more grotesque it is now today, especially the 4-step procedure here, whose awkward erosion and grotesque manifestations have been the bane of the times, above certain theoretical assumptions. My learned friends have raised a theoretical argument, which in reality have fallen into a morass of personal and political degradation. We should, we think, defer to this legislative wisdom and perception. The choices and constitutional adjudications quite clearly indicate the need for such deference. Let the end be legitimate. Let it be within the scope of the Constitution. and by all means which are appropriate, which are adopted to that end. And here we have added, I have added 4